Good morning, good afternoon. I'm pleased to be moderating the third interview of the series organized by Berkeley Global Society on arbitration and dispute resolution. Our worldwide legal flight lands today in the United Arab Emirates in fabulous Dubai, as our special guest is Habib Al-Mulla, Executive Chairman of Becker and McKenzie, Habib Al-Mulla. As a litigator, I'm so keen to learn from Dr. Habib, one of the most well-known litigators in the Middle East, that I decided that it would be a good idea to get the support of a more impartial colleague and arbitration practitioner, our co-chair, Flavio Peter. Dr. Habib and Flavio, good afternoon.
Good afternoon.
Good afternoon, Matteo.
So let's talk about the origins of your life as a litigator, Dr. Habib. One might expect that a great litigator had always dreamt of fighting in court. Instead, Dr. Habib famously told the media he never expected to pursue a career in law. Dr. Habib, we are very curious to know your version of the story.
I know this is quite a strange statement, and many of my colleagues sometimes are surprised with it. I mean, to be frank, at the time when I graduated in the 80s, the optimal dream of every graduate was to be a seasoned bureaucrat, work with the state, with the government, either the Ministry of Foreign Affairs or the Attorney General's office, or, I mean, that was the kind of the job that everyone wanted to have. Being a lawyer was nothing or not something that people pursued. And that was, in fact, my plan until I think one or two nights before applying to the university, I met one of my relatives and he asked me, what are your plans? I told him, well, I'm thinking of joining the Ministry of Foreign Affairs. He said, why don't you become a lawyer, study law? That was the first time that hit me. And I said, what am I going to do with the law? He said, oh, you have many opportunities. You can be a lawyer, you can be legal advisor, you can work with the government, with the private sector, with banks. Now, what really caught my attention is that it has many opportunities studying the law. So I applied. We had three choices and I applied all of them law, to the extent that the registrar was a bit surprised. He said, don't you want to put another option? I said, no. It's law and I just want to go with law. And that's how my career started. So it was merely by coincidence, something that I have never planned for.
Thank you for sharing this. Then you graduated from Cambridge and Harvard universities. How did the time spent as a student at Harvard and Cambridge influence your attitude toward life?
See, I believe studying in a different university, in a different country, sometimes in a different legal system, it's not a matter of having more knowledge. Knowledge can be received in your own jurisdiction, in your own country, in your own university. But it's about meeting different people, different cultures, knowing different styles of learning, of teaching, and really becoming a matured person. And I think, I firmly believe that I would not have achieved what I have achieved if I did not go to a different jurisdiction, a different university, a different country. Now, it doesn't mean necessarily that you need to be at Oxford or Cambridge or Harvard, but see a different regime, see a different system, meet different people, see how they react to things, how they deal with legal issues, how they provide solutions. I think it seriously broadens everyone's scope. And I firmly believe that it's a must for a lawyer who wants to be successful, who wants to be a kind of, I would say, international lawyer.
I fully agree with you. So, of course, you would suggest to a young law practitioner to study abroad. And Arabian Business Journal defines you as the top legal of the Arab world and a litigator born to win. Your interviews are very famous for having a knack for predicting the future. Now, we would like to challenge you starting from the past of your country. How would you compare the situation of your country now with that of 30 years ago?
Well, there are things that have significantly changed. I mean, when I practiced law or started practicing law, we didn't have codes. We were in fact using Egyptian codes, sometimes Lebanese or Syrian codes. At the time, the state was young. We were only a handful of lawyers. I remember going to the court and every lawyer in the courtroom knew his colleague. Today, of course, I think we have a comprehensive and sophisticated set of codes, which to some extent, in some areas at least, especially when we talk about, for example, technology aspects of courts, are far advanced than other countries in the region. So there has been a long way that the UAE has crossed in the past 30 years. Now, that does not mean that we still don't have other things. For example, we don't have still a capital markets law. I think that's a very important law that you should have, being a financial capital in the region. Things have moved, in fact, in a fast pace in the last 4 or 5 years. I mean, I'll give you an example, the criminalization of bounce check. I've been advocating for like 25, 30 years that we should decriminalize issuing a bounce check. It was one of the taboos. No one thought it's going to happen. However, in the last two years, we have seen significant improvement in this. Foreign ownership is another aspect. So I think UAE has improved a lot, has come a long way from at the time when I and my colleagues started practicing law. But this does not mean that the job is finished. I think still we have miles to cross. We have always to be on our toes, because others in the region, other economies, other centers will always try to compete. So if a country wants to be ahead, it has always be ready to challenge itself, challenge its neighbors, challenge its competitors, and always strive to achieve the best.
Thank you very much. You anticipated many of my questions, but so I believe it could be useful to move to our profession and turn to your amazing track record on dispute resolution. Newspaper reports that one of your first high-profile cases was in the year 2000, when you defended the 21-year-old British national Lee Ashes, who was accused of hacking into Etisalat and crippling the UAE's internet system. What aspect of the court hearing you like most, and how your approach, strategy, court changed over the years?
Yeah, I think this was one of the first high-profile case that I had. I still remember it very well. I mean, the hacker really undermined the whole country's internet system. There were rumors that it was a foreign plot and so on. And this poor guy, 17 years old guy, was there, not knowing what he has done and how the people really wanted his neck. So the first thing I thought is that what we need to do is to win this case, not in the courtroom, because if we want to win this case, it cannot be won in the courtroom. We need to win it in the public opinion, because it was a public opinion case. And I recall that I started using the media to defeat the public and the first story that was published everywhere. And it was because we won the public opinion, this matter became very kind of famous. and we managed to win, well, with a minor fine, considering what accusations were given and what charges were given to this guy. So what I learned is that you need to think out of the box. Sometimes you cannot only win in the courtroom. You need to think out of the box and see what other factors will assist you in winning the case.
Thank you. I agree, and also in our civil litigation, we have a similar situation in complex cases in Italy. So I understand your statement. In your oral pleadings, do you follow different strategies before national courts or arbitral tribunals? And what's the secret for drafting a persuasive brief? Should it be concise or very thorough? Must it be measured or aggressive? What's your thought on that?
Well, I think first, of course, you need to know whom you are addressing. For example, a common law arbitral tribunal is different than addressing a courtroom following the civil law system. So the first important is you need to know your audience. You need to know the judge that you are dealing with. You need to know the prosecutor you are dealing with. You need to know the arbitrator. What is his style? Some arbitrators, for example, prefer written evidence. Some prefer oral evidence. You have to plan your strategy accordingly. That's the first step. I personally prefer more precise sort of drafting because I act sometimes as an arbitrator. And when you have very lengthy memos, you have to exercise a lot of effort. Sometimes you get bored, sometimes the idea gets lost. So if you are precise on the point, you make sure that the person who's reading you, who is listening to you, will get your point. Now, this does not mean that you leave any stone unturned. Everything has to be dealt with. Even if there is a defense that you think it's irrelevant, it's not that important, it's weak, it could be that particular defense that will catch the eye of the judge or the tribunal. So everything should be addressed, but in a precise, concise manner, not in a lengthy, repetitive manner. I have seen sometimes lawyers just repeat themselves, continue repeating themselves, and this is one of the worst things that a lawyer can do, because it means that you are running out of ideas and you are just trying to repeat what you have said in different styles and different forms. It's not going to work.
Thank you. In Italy, we are trying to put a limitation in number of pages in order to meet your suggestion. So I agree. Your law firm assists giant multinational, royal families, funds, and investors, and it is possible that in a dispute, the chances of success appear to be very limited after a prima facie analysis. Is it important for a successful litigator to be able to say no to his client, and how to do that?
Absolutely. I think if the lawyer cannot say no to his client, then he's a weak lawyer. One who cannot gain the confidence of his clients. There are many cases where a client comes to me and I look into his case and I tell him that, I think that you have no case. If still you want to proceed, it's at your own risk. You should understand this, but it would be difficult. You have to be able to tell the client frankly if he has a case or if he doesn't have a case, so he understands the consequences. Because the worst thing is to raise the expectation of the client, and then you realize that you lose not only the case, but you lose his confidence, you lose your reputation, you put everything at risk.
Yeah, thank you. You made it very clear. In the last 30 years, the Habib al-Mulla law firm successfully assisted its client in dispute resolution related to different industries and fields of law. bank on financial litigation, construction litigation, investment litigation. In your opinion, should a successful litigator be focused and master a specific field only, or be capable of providing a 360 degrees assistance in different fields to the client?
That's a very interesting question. And it's a question that does not have yes or no. I think it has yes and no answers. Yes has to be specialized in a certain field, because that would give you the depth of knowledge that not only the lawyer needs to win, but also the client needs to win the case. A lawyer who works in each and every aspect of the law, in my personal opinion, cannot master all of them. He can do a decent job, but I think when it comes to complex, sophisticated matters, he may not be able to master them well. Now, on the other aspect, when you are, for example, working on a certain issue, you need to understand 360 degrees of that particular issue. For example, if I'm defending a construction case, I need to know all the aspects that I can on the construction business, not only from the legal point, but even from sometimes the technical points, because you will have witnesses that you need to listen to, you will have experts, you need to be able to understand if they are saying accurate information or not. And the only way to do that, if you understand, master that particular issue.
Thank you. I'm on the same page with you also on that. Let's move to arbitration with Flavio, and let's see if you agree totally like with me.
Thank you very much, Matteo. Dr. Al-Mulla, before I enter into some questions on arbitration, we just had a question from the audience, which I think suits actually quite nicely here, because you have been talking about in our profession as let's call us dispute resolution practitioners. We also have to deal into the technical aspect, so in substance, be it construction, engineering matters. Now we have a question here from a viewer who has an engineering background, but he says he found it very interesting to study law. And his question to you is, what would your advice be to someone in his situation that studied law at an older age and wants to shift his career to ADR? How should he or she pursue such a move from engineering to ADR? What would be your advice?
I think, in fact, that works in his favor. Because, for example, if I was a client and I had a construction case, and I know that there is a lawyer who has studied law, but at the same time he has studied, for example, engineering, I would be more inclined to go to him because I believe that he has knowledge on both aspects. Mm-hmm. And this is not something unusual. I have encountered lawyers who have studied engineering, lawyers who have started their practice studying medicine, for example. It helps a lot. And in his case, I think if he currently specializes in ADR, take courses, get some degrees, it starts to get some cases, I think he will have a competitive advantage than his competitors because he has better knowledge. And knowledge is what everyone seeks.
Yes, I agree. And then I guess the second step would be, but that's my experience, that would be just to show up at conferences, get into contact with the community, enlist as arbitrator on panels if possible, and that is how maybe one can develop one's career and create a footstep somewhere. Would that? Absolutely.
And writing articles. I think one more important than just attending the conference is being able to, for example, to participate in speeches and writing articles, because then you will be seen as a reference. And once you are there, it works automatically. Of course, attending conferences, building contacts and connections is also very important, because that's how you get your name spread, especially at the early stage.
Yes. Thank you very much. And I hope that answers the question raised by Mr. Mickey. It was Mr. Fakey, sorry. Now, you said before that you obviously you have acted on the different sets of rules. You act as both as counsel and as arbitrator. For you personally, do you prefer one or the other function, one or the other role, or is your passion with both?
I think passion of both, but when you start getting older, I think you prefer to be on the bench.
Is it because of the deadlines, or is it because of an emotional aspect that you not necessarily feel like arguing all the time for a case?
Partly, yes, not feeling always arguing, but also I think when you spend like 25, 30 years, you believe that you have certain knowledge, you have certain understanding on how to deal with issues, and you believe that you can add value when you are on the bench, because then you are in fact dictating the case. You are in fact controlling it. You are in fact writing the award. So I think it's more of self-satisfaction rather than anything else.
Mm-hmm. I understand. I understood from what you said before that they are quite complementary, those two roles, in a sense that from counsel work you might better understand what the arbitrator needs and vice versa.
Absolutely. I believe that the best arbitrators and even the best judges, those who have practiced law as lawyers and advocates, because they understand what it takes to prepare a defense, to submit a defense, to prepare a witness. So they have better understanding than those who have not practiced or acted as practitioners. Those who came directly to the bench, they don't understand what's going on. They don't understand how, for example, the whole industry, advocates industry works. And it is industry today. Today, it's not just an advocate taking his file, going to the court. Cases has become much more sophisticated. There are multinational jurisdictions that involve some cases. There are cases which have very different technical aspects. You need to have expert. The whole world of litigation has become more complex, more sophisticated. And those who have really worked in that system have better knowledge on how that system works.
Mm-hmm. I understand. Also, before, at the beginning, you explained that when you started practicing law, the UAE didn't even have courts or a court system in that sense. Did that fact facilitate arbitration and boost arbitration differently than in other regions of the world? Because it was maybe easier to set up an arbitration system due to a lack of other judicial bodies? Or am I going in the wrong direction with my assumption here?
I believe not. I am a firm believer that things work better when there are clear directions and boundaries. Without clear directions of boundaries of law and regulations, it becomes chaos. For example, when I started practicing, when there were no codes, we have different judges from different countries, and everyone was applying his own understanding of how a matter should be dealt with. So someone, for example, would admit a witness, someone would not admit a witness on a similar case. There was no guidance. Everyone was working from his own background. It's not, I wouldn't maybe use the word mess, but it was confusing for clients, confusing for practitioners, confusing for everyone. When there are clear guidance from law and regulation, everyone understands what needs to be done. Everyone acts within those boundaries. Yes, there may be a different understanding of certain aspects of the law, but that's the beauty of it, because then it triggers different understanding. It triggers creative thinking on certain aspects of the law. And that's how the law becomes more mature, more rich, more in-depth.
Understand. Let's maybe talk quickly about the arbitral institutions in the UAE, particularly looking at the Dubai International Arbitration Center, which to my understanding is one of the biggest, if not the biggest arbitration center in the Middle East. In your view, what can the DIAC learn from other major institutions such as the ICC or the LCIA or the Stockholm Chamber of Commerce?
See, I am a firm believer that arbitration is a sort of a language. It's a universal language and everyone understands that language. I feel very reluctant when countries try to come up with their own ideas on how to draft arbitration laws, and they go in different directions. It only causes confusion. There are the unilateral rules, for example, everyone understands them. Every country should try to adopt as much as it can from those rules. Yes, there may be certain specific aspects that you need to fine-tune in order to meet your own special requirements, but at least we speak the same language. There are the ICC rules, for example, the LCIA rules. In general, I think 90% of the arbitration rules worldwide are similar. So I don't understand when there are certain local legislations try to come up with their own ideas. They make only confusions, and they lose the attractiveness that is needed to make their city an arbitration appealing destination.
If I hear you, does that mean that you might also be somewhat critical to some arbitration rules, particularly with regard to the constant revisions done? Because I would fully agree. Originally, I guess many of the rules were very similar. Also, the Swiss rules that we often apply are based on the Untitled rules. And we might have had even more in common, let's say maybe 15 years ago. But in the last 15 years, a lot of the major institutions have revised the rules. They take this feature, they take this feature. What is your view on that? Do you say, is that creating confusion as well, or not so much?
Not at all. I think it helps. For example, when I was chairing DIA, we realized that our rules go back to 2007. They are old. They need to be updated. The ICC has come up with its own new rules. Singapore, SIAC came up with its own rules. There were new aspects in arbitration world. For example, third-party funding, joining parties who have not signed the arbitration contract, but they are related, and many other aspects. So what we did is that we had a look at different best practices around the world, and then we started upgrading our own rules. And I think the current board is working of DIAC are working on those rules, and hopefully they will enact them soon. So as I said, because it's a universal language, everyone will benefit from other centers, experiences, expertise, even the wrongdoings. If, for example, is a particular center in some place come up with a draft law or a draft regulation or that proves to be wrong, and then they rectify it, for me, I would learn from that mistake in avoiding it, or treating that situation in a better way.
Yes, absolutely. You were before also referring to the attractiveness of certain seats of arbitration. For our viewers, in this room, but also watching from abroad, in your view, what makes Dubai an ideal seat for arbitrations as opposed to the other notorious seats?
See, I think the success of the arbitration centers in Dubai, whether it's DIAC or the IFCL CIA or the Maritime Center or any other center, is the story of the success of Dubai. Dubai is successful as a mercantile hub, attracts investment, attracts different multinationals. And because Dubai is successful, because it's less bureaucratic, because it's investor friendly, arbitration in Dubai is successful. So part of it, in fact, relates to the success story of Dubai itself. The other aspect is that I think at least I'm talking about DIAC, that's my experience with DIAC, because they have adopted a very flexible approach. You can appoint any arbitrator from any part of the world that you want. There are no restrictions. You can choose whatever language you want. You can choose whatever law to apply on that on your contract. So giving the parties as much freedom as they want in drafting their own rules and constituting their own tribunal leads to that center being appealing to everyone and leads to that center being successful. And that's, I think, one of the main reasons why DIAC has been successful. The level and the scope of flexibility and freedom that it has provided to its users.
Are the courts in Dubai also as arbitration friendly, just as much as the rest of the let's call it infrastructure, but also legal infrastructure? Are the courts also as arbitration friendly, be it as with regard to challenges or?
Yeah, personally, I believe not in Dubai but worldwide, courts have some sort of resistance to arbitration. Maybe historically, and many countries went into that learning curve from the courts being hostile to arbitration to courts being friendly to arbitration. The approach of the UAE courts, I think like 10, 15 years ago, was hostile to arbitration. I think they didn't have that much trust and confidence. Things have changed. We have seen different judgments coming, favoring arbitration proceedings, favoring the enforcement of arbitration awards. Then we have the new arbitration law that was enacted a few years ago, which even provided more guarantees and accreditation for the arbitration proceedings. So I think we are coming to the end of that learning curve whereby the courts are becoming arbitration friendly, the whole jurisdiction is arbitration friendly. I think we are going in the right direction, and it's just maybe a few more years and we can blindly say that the UAE is an arbitration-friendly jurisdiction.
Right. Thank you very much. That was very insightful. With that, I hand over again to Matteo, who's got some more questions.
Thank you, Flavio. Now, the next session is about Dr. Habib and law reforms. So I take the opportunity to grab a question from the audience. And the question is, what is the matter, the legal question that Dr. Habib regretted dealing with?
I don't know, I mean, if I've regretted anything, but I recall that recently, I think it was just last year, normally when I deal with a client, I'm able to understand whether he's telling the truth or not. I'm able to understand where are the weaknesses and the strength of his case. But despite all my experience, I have to admit, I think it was last year or a year before, it was just before COVID, I met a client who explained his case. He was so confident. Yes, I have all the documents. This is the case. I've done nothing wrong. All my transactions are recorded, everything. And for some reason, I don't know, because he was my classmate when I was at the high school, because he was so convincing in his approach, I really believed him. I thought, yes, this guy is genuine. And of course, we took his case. When we went to the court, we realized that everything that he told us was wrong. Whenever he said, I've never signed a document, he has signed that document. Whenever he said that I've signed a document, he has not signed a document. Whenever he said that there was an auditing report, there was no auditing report. Everything he told us was wrong, and it was quite embarrassing for me, because I was defending the case, and every day I was realizing that this guy has really misled us. So if there was a case, or there is a case that I'd regret taking it, was that particular case.
Thank you. It happens. I understand. Let's move to the audience must know that Dr. Habib is famous for anticipating the development of the UAE law. Do you think that law number 26 of 2020, introducing 100% foreign business ownership, will add fresh impetus to the economy?
Absolutely. I've been advocating this, and I've written an article on this, I think in the 90s, calling for, at that time it was kind of a taboo to have 100% foreign ownership. I believe it's a step in the right direction. I believe even it came late, but late better than never coming. It will boost investors' confidence, because they can, I mean, currently or before this law, what was happening is that people were resorting to side agreements, which was reflecting their actual arrangement, which was completely contrary to the formal agreements that they were submitting to the authorities. Why do this? I mean, if the market is driven by a certain direction, if that direction is not wrong, why not allow it and regulate it? And that's what the law has done. Allow 100% foreign ownership. If there are certain aspects or certain categories that you believe should be protected, then specify those categories. If there are categories that you would not need them to be protected, then just allow them. And let the market forces drive events. Artificially regulating the market is completely wrong. Market is mature. The regulator should interfere only to put the guidelines, protect certain interests that are of a supreme importance. But other than that, too much involvement, too much interference kills the market. The regulator should watch and interfere when it is necessary. Other than that, let the market drive itself.
Thank you. You made it very, very clear. So let's discuss about financial markets. Do you still believe that cryptocurrencies and blockchain are the future, must be regulated? And do you think, taking into consideration also the risks of COVID-19 variants, that the market will be subject to further shocks in the near future?
Okay, let us deal with the cryptocurrencies first. I think it was 2 or 3 years ago when I gave a lecture on this, and I said it's going to be the future. Regulators need to start regulating it, not avoiding it and ignoring it. At that time, everyone thought, I think I was exaggerating. What we see today is that regulators are slowly trying to regulate it, slowly trying to recognize it. Regulators hate what they don't understand. And I think part of the problem is that they don't understand how cryptocurrencies work. But it is there. We can't just close our eyes and say it's not there. It is there. It is going to grow. People want it. There is a need for it. There is a market segment that needs to be fulfilled. So rather than leaving it completely unregulated, why not regulate it? And there are certain regulators that have started doing this. And I think it's a direction that will be pursued by the other regulators. It's going to be continued. So yes, I believe that is going to be the future. I believe also that maybe in 10 years, the paper currency that many people are using are going to disappear. Who's going to use paper currency with all the costs and the risks involved in it when you can do any transactions using your iPhone? I mean, I was in Moscow about 2 or 3 months ago. I don't recall needed to get my wallet out. Everywhere I was using Apple Pay, even for small transactions. Why do you need to carry money anymore and take that risk? So from that aspect, I think, yes, it is going to grow. It is going to be the future, and regulators need to regulate it. What was the second part of the question?
Yes, what if COVID-19 will provoke further shocks in the near future to the market?
Personally, and I've said this before, at early stage, that's not going to happen. COVID-19 is not like 2008 situation. 2008, the fundamentals were wrong. So when it collapsed, the whole house of cards collapsed. It affected everyone. With the COVID situation, the fundamentals were right. Everything was going the right direction, whether it's tourism, whether it's industry, whether it's transportation, whether it's logistics. But the pandemic happened, it gave a hold to everything. Once there is a control over the pandemic, either through vaccination or herd immunity or this, the fundamentals are there. They are just going to go back. And that's what we are seeing, because people are now starting to just live with the situation. Allow opening markets, allow opening activities and businesses, put certain rules and regulations, and go back to normal.
Thank you for sharing your point of view. I have the last question before passing the word to Flavio. How is taking proper and strong action against corruption and grant transparency important to attract foreign investors? And I would like also a few ideas about the free zones in Dubai.
Yes, I think it's an utmost important for any jurisdiction that wants to attract investors to be transparent and to be doing, but wants to invest in a country or in a jurisdiction where there is high corruption. Maybe if there are very high benefits, some may take the risk, but that will never be an investment friendly or attracting jurisdiction. So it's quite important to be able not only to fight corruption, but also to show corruption. I know that there has been always statements that oil free zones and offshore zones are places where people evade taxes and so on. I think that is to some extent an old understanding. I believe today there are quite strong regulations, anti-money laundering regulations, anti-terrorism encountering regulations. So I believe that even free zones today, yes, you may get, for example, 100% free ownership that you may not get on a mainland. You may get certain aspects of a jurisdiction like common law jurisdiction that you may not get on the mainland if we compare, for example, the DIFC. But other than that, I believe most free zones today comply with anti-corruption, anti-money laundering regulations.
Thank you very much. Flavio, let's talk about giant law firm.
Thank you very much. Yes, my pleasure. Because it is quite interesting that, to my understanding, Dr. Habib Al-Mulla, you have been running a law firm for more than like 28 years or so. Before then, your law firm, as it was originally called, joined the Baker McKenzie network. I think you already had at that time maybe 40 lawyers, and your team has grown even more now. I mean, my question to you spontaneously would be, why would you do that? Because you have already had such a successful law firm. So what are the advantages, maybe? What is the benefits, but also what are the challenges?
I think this is a very important question, and many people, in fact, ask me about this question. You see, where we have reached a situation that we became a large, medium-sized firm. And this may not apply to all jurisdictions, but in certain jurisdictions, the law firms that are penalized most are the large, medium-sized firms, because they have all the costs that involves large firms, from HR, IT, marketing, and so on, but they don't have the big tickets that the big giant law firms have. The boutique small firms, they don't have that cost. So in fact, sometimes they are even more profitable than the medium size. And even the other thing is that we had a strong client base that had international requirements, doing business in different jurisdictions, doing issues, wanting to invest in different jurisdictions and so on. But when they had to go to some other jurisdiction, they had to use another law firm. They would ask us, okay, which law firm you would recommend? We would tell them, this law firm, do you know them? No, but we have heard of them. We have not dealt with them. I think the combination of having a platform that has the international reach, but at the same time has the local expertise and the local connection in the market provides to the law firms and to the clients an optimal opportunity to maximize the benefits of that. So today, for example, I have a client, a local client, who says that I have a transaction or investment in Hungary, for example. I can have, yes, we have an office there. I know the partner there. We have dealt with him. You are dealing with one law firm. You are dealing with one stop shop. You don't need to go to some other law firm, and vice versa. Now, is that a risk-free ride? No. The challenges that come with it, of course, the first thing I can think of is when you are a part of a large law firm, particularly when you focus on litigation, there are always risks of having conflicts and having to abandon cases and having to regret to some of your clients that you can't take the case because you are conflicted with some other office in some other jurisdiction. Many clients are sophisticated and understand this, but some don't understand. So the conflict is a big issue. The other thing, of course, when you are in a small firm, the decision-taking process is much faster than when you are involved in a large firm, because you have to look at the interest of the whole firm, all the offices, not only your particular office. So it comes with a risk. It's an experiment that we have been through. I think so far it has been successful, and there are other law firms who are looking into this model and trying to copy it.
Yeah. Yes. Thank you very much. And if we now, take this development on a HR level, as mentioned, like your team has grown.
Hello, I can't hear you.
Oh, sorry. I hope you can hear me now. That yes, sounds good. Okay, great. So if we take this development of growing within the Baker McKenzie field also on a HR level, so your team has grown from maybe originally 40 to 50 and even more now. Particularly in times of COVID, what would your advice be? What would your tips be for maintaining team spirit, for maintaining a firm culture in your own firm? How did you deal with that? And what would your advice be?
See, I was reluctant and against the
Sorry, we lost you. Unfortunately, we have a technical issue.
That some law firms took, for example, of
okay, that happens. As you see, he is on the road, so the connection is not always superb, but we'll try to reconnect with Dr. Habib. And as soon as Dr. Habib is back, we can take it up again. Dr. Habib, can you hear us?
Dr. Habib, maybe you should switch off the video, so maybe the connection.
Hello?
Yes.
Can you hear me now?
Yes, we can hear you now. Maybe for the connection, it is better to, if you wish, you can switch off the video, so your connection for audio might be better, as you wish.
Yeah. Okay, I'll try to do that. Can you hear me now? Is it okay?
Yes, we can hear you and we can still see you. But we did not get the your response to below. So sorry about that. I'll give you the floor again.
Yes. No, it's okay. Okay, what I was saying is that I was in fact against the approach that some companies took, for example, to lay off people, cut their salaries, and so on. I believe that if you want your lawyers to be loyal, to work hard, you need to stand with them at the time of hardship. It was a hardship that everyone went through. For example, we didn't take that approach. We kept all our force. And the other thing you need to do is to realize the opportunities. Yes, certain aspects of business may slow down, but there were certain aspects that could grow. In Dubai, for example, we saw that the market is going to bounce quickly. And that's what happened. Our results, even for this year, is better than our expectations, better than the budget that we had, because the market has bounced. As I said, the fundamentals were right. So what you need to do is to keep the team spirit. You need to make sure that every lawyer, every member of your team, not only lawyer, but even the supporting service, feel that they are important, feel that they are appreciated, and at this time, they will stand with you at hardship times. That's one of the most important aspects of building a team spirit.
Yes. Well, that's great to hear that, like, first of all, for your own office, that you joined it together through the hardship, but then you overcame it quite quickly. So that is a great result. Before I hand over to Matteo, and we will just quickly have another question on the future, I have a question from the audience that goes in that direction as well. We have someone from the audience who asked you what your opinion is about the future of arbitration.
Yes.
Sorry, did you hear the question? The question would be, what is your opinion about future of the arbitration? Where do you see it go? Oh.
No.
Sorry, we cannot hear you.
We cannot hear you.
Multinationals, when they are working in different jurisdictions, and they need to see the appearance of a neutral bench. However, I believe that the alternative dispute resolutions like mediation is going to grow. People want to avoid, especially businessmen, the lengthy process that litigation and arbitration involves, the cost that is involved in arbitration, the bitter taste that is left once a case is included for the losing party. Because if you are dealing with a company and you want to continue doing business, you want to do business even after you win the case, after you lose the case. Now, once you go into litigation, sometimes even in arbitration, unless the management changes, that kind of animosity continues to be there. With mediation, the situation is different. You conclude the mediation, you shake hands, everyone is happy, everyone is looking further to continue. So I believe personally that mediation is going to show significant growth in the coming future, particularly because of the COVID situation, because of the difficulties that the companies and businesses went into.
Okay, thank you very much, Dr. Habib. I hand over to Matteo.
Thank you, Dr. Habib, for your insightful answers, and fully agree with the importance of mediation. We are here in Italy, we are trying to amend our civil code accordingly. in our interviews, we like to talk about happiness. That is because we believe and hope that good lawyers and consultants could be wise and happy as well as successful. So my quote of the day is from Persian writer and mathematician Omar Khayyam, who once said, "Be happy for this moment is your life." After COVID-19, what do you expect from this moment, Dr. Habib?
I think you have quoted one of my favorite poets. I like Omar Khayyam. Hello?
Yes.
Yes. Al-Khayyam is one of my favorite poets. And I think, as I said, one needs to look into COVID-19 as an opportunity. For me, for example, especially during the lockdown period, I focused on learning new techniques, new language, learning sports, doing some sort of sports that I have been ignoring for a long time. So for me, I think it was an opportunity. It was not an issue at all.
Thank you very much, Dr. Habib. Flavio, it's up to you for the conclusions of this interview.
Well, we have gained a lot of insight. Thank you very much, Dr. Habib, for your time and for making it time even during travels. And we have seen many interesting features, and we have learned that we cannot always win at the courtroom, maybe not even win before the tribunal. So we will be thinking outside the box and maybe use media to win a case or to win on whatever other level. It was an absolute pleasure, Dr. Habib. We thank you very much on behalf of Berkeley Global Society, on behalf of the Institute of Arbitration of BGS, and also on behalf, I think, of myself and Matteo.
Thank you very much.
That it was a great pleasure, and we wish you all the best.
Thank you, Flavio. Thank you, Matteo. It was a pleasure being with you. And sorry for the bad connection.
No problem at all.
No
Thank
problem
you for
at
making
all.
the time. And take care.
Thank you,
everybody, for joining.
Bye.
Bye.
Thank you. Bye-bye, everybody.